The first clause of the 14th Amendment, the Equal Protection Clause, says that no state may deny to any person within its jurisdiction the equal protection of the laws. Over a series of cases, the Supreme Court ruled that this clause prevented states from disenfranchising or removing the vote from a range of citizens. Ramirez, along with the other plaintiffs, had been convicted and jailed for felonies, and this resulted in them being refused voter registration under Californian law. They appealed, citing the protection of the 14th Amendment and also arguing that preventing them from voting was inconsistent with the rehabilitative purpose of criminal law. However, the 14th Amendment also includes a second clause which says in part that when determining the number of representatives each state has in the Congress, numbers are proportional to the number of electors. So if electors were excluded, for instance on racial grounds, the representation in Congress might diminish. However, the second clause carved out an exemption, so there would be no reduction in representation if people were disenfranchised due to participation in rebellion or other crime. This seems to suggest that states must be able to disenfranchise criminals, or else why would such a carve-out exist? The Supreme Court agreed, but in order to be certain, they needed to ensure that the word crime had the same content, the same meaning, when the amendment was framed immediately after the Civil War. The judgment went deep into the history of the provision and the debates which surrounded its framing, and ultimately the justices said, "We hold that the understanding of those who adopted the 14th Amendment, as reflected in the express language of Clause 2 and in the historical and judicial interpretation of the amendment's applicability to state laws disenfranchising felons, is of controlling significance in distinguishing such laws from those other state limitations on the franchise which have been held invalid under the Equal Protection Clause by this court." They did note the contention that this was all inconsistent with a rehabilitative criminal law, but the judges quite fairly said that considering such arguments was a matter for the legislature, not for the courts, and the legislature in California had clearly formed the view that disenfranchising those voters was in the public interest. It is therefore not contrary to the 14th Amendment for a state to remove the voting rights of felons.